Ladies and gentlemen, thank you for standing by, and welcome to the Knowledge Leadership webinar. During presentation, all participants will be in a listen-only mode. If you'd like to ask a question during presentation, please use the chat feature located in the lower left corner of your screen. To reach an operator at any time for assistance, please press *0. As a reminder, this conference is being recorded Tuesday, September 23rd, 2014. I would now like to turn the conference over to Robin Thompson. Please go ahead.
Good day, everyone. On behalf of all the team at BIA, welcome to September's Knowledge Leadership webinar, where our panel will be taking a 360-degree look at legal hold. Before I introduce our speakers, I just want to give a brief reminder of our housekeeping rules. As Claudine said, please submit your comments or questions through the chat window, and we'll bring those up at the end of the program. Also, as you leave today, you'll be prompted to answer a short survey, and we would appreciate your help in doing that. It is your feedback that drives the curriculum for our Knowledge Leadership series, like programs today. Now, it is my privilege to welcome our panel today. Our program is being moderated by Alon Israely, who is a co-founding member of BIA and leads the Strategic Partnership Programs. Alon has over 17 years of experience consulting with corporations regarding e-discovery, legal hold, and preservation. He is a frequent speaker and sought-after expert, a licensed attorney, and has the distinction of being a certified information system security professional. He's joined today by Barry Schwartz, who has over 35 years of legal and business consulting and is currently Vice President of BIA's Advisory Services, where he assists clients with IG, RIM, and discovery management. He is a licensed attorney and has the distinction of being a certified e-discovery specialist. And finally, we're joined by Peter Corellis. Peter is a nationally recognized authority in records management and information governance with over 30 years of experience in a variety of industries in the United States and abroad. Peter is currently the president-elect of ARMA International and has the distinction of being a certified records manager, a certified archivist, and was among the first to hold the distinction of ARMA's certification as an information governance professional. And with that, Alon, I turn the program over to you.
Thank you, Robin. And we're going to jump right in. I know we're just a couple minutes late here. I do appreciate everybody being patient. So we really wanted to take this opportunity to talk about legal hold and the duty to preserve data for legal matters from a broader perspective, and really looking at it from three critical areas of the organization. That's legal, the records information management side or information governance, and IT. And those are three really critical roles because ultimately those three organizations within the company have the bulk of the work with respect to managing and maintaining legal holds. Now, we're going to do a little bit of an overview at the legal side, a little bit of an overview of the records management side and on the IT side. And what we're going to do is we're going to really try to make this a practical webinar today. So we're going to hope to give you as many kind of tips and tricks as possible and also talk to you about some practical applications. Our goal is that at the end of this webinar, you can go back to your kind of normal job duties and have at least brought with you some piece of information or several pieces of information to help you kind of with going forward. So let's start with the legal side of things. And before we do that, I want to just kind of level set everyone here, and the best way to do it, maybe this is putting my lawyer hat on, is to talk in terms of language. So there are a lot of different words that we use in this realm, and these are just a few that kind of help us get on the same page. So custodian is really the lawyer's term for user, which is what the IT person calls that, the individual, and employee, which is what the manager calls the individual. And so you may hear us jump between some of these words, but ultimately they all mean the same thing, which is a person at the company who may have documents that have to be retained. Legal hold, this is an interesting one because depending upon who you talk to, it means different things. And I think this is one of the things we're going to talk about today, and I'd be interested to hear Peter's take on it, which is when you say legal hold and you're talking to a corner office partner at a law firm, they mean one thing. Usually they mean, oh, I've got everything covered. Everyone's been told of their obligations and everything's been preserved so that 8 months later or a year and a half later, I don't have to worry that some email is missing. You talk to a records information manager and they may think in terms of just the IG-related tasks, the actual activities that they may have to do with respect to certain records or documents and how they have to be managed inside of mostly structured systems. So in the nutshell, my experience has been that the information governance people don't necessarily think about legal hold in terms of the notification side. They mostly think in terms of what has to happen to the records, to the documents. And then, of course, you talk to a legal, like a paralegal or someone in the legal department, and they may think of legal hold as the actual act of notifying their users to not delete. So the point there is that the word legal hold, preservation, they all kind of mean slightly, well, they mean the same thing, but they're talked about in slightly different ways by different roles. Documents, of course, documents, data, information. I always like to joke that only lawyers can take a word like data and turn it into 3 long words like electronically stored information. But ultimately, when we say ESI or we say documents, we say data, we mean the same thing. In the records information management world, obviously records has a very specific definition, which is why we say it says possible or possibly a record. Maybe Peter can talk about that a little as well. And data collections really is the gathering of information or securing data so that later on you know that you have it preserved. So again, just kind of being able to get on the same page with language I think is very important. And frankly, this is something that you should be doing inside of your organization. If you're going to have a team of people who are coordinating these activities, effectively what is the business process of preserving data inside the corporation, then I think it's important to have a document or at least a conversation so that everybody on that team or everyone doing that coordination are using the same language. So a little bit more about preservation and how we mean it in kind of the broader sense. What is it that we mean by preservation kind of from the legal hold perspective? It's what happens on CorpNet, behind the firewall, so to speak, to use some kind of traditional IT language. And ultimately, you're talking about 4 main steps. You're talking about identifying data and systems and people, those things that may contain information. You're talking about notifying employees, but also IT. You're talking about having IT suspend certain tasks, certain data disposition practices, for example. If you have 90-day retentions on your email, you don't want to have the legal team send out a hold notice while on the back end the email archive or the email system is deleting data after a certain point. And then, of course, you want to be able to preserve the data in the documents, whether you do that kind of in place, which we're not big fans of. There's a lot of IT headache behind that. Or if you're just grabbing a copy in a forensically sound or defensible manner and setting it aside. But that notion of preserving the documents are really important because if you think about the earlier definition of the lawyer thinking, when I say legal hold, I know that 10 months later I'm going to have that email and it won't be deleted. That's really where that last preserve comes into play. And I'm just going to kind of finish up here with the broader definition, and then I'll probably turn it over to Barry, let him talk about kind of the legal aspects, or at least legal hold from the legal perspective. But before we do that, just again to kind of cap the idea of getting on the same page with language, preservation really is all of those things together. So when we say preservation, we are talking about that legal duty to do all that stuff like notify employees and ensure that the IT department has suspended certain practices to ensure that people are not deleting and that you actually have copies of that stuff. And importantly, you see at the end here that all of those organizations, the legal department, the IT, and the IG folks, are all working in coordination. And so it's not okay, for example, for the legal department to send out a legal hold notice or to notify employees and not to let the records managers know that that's in place so they can go ahead and do what they need to do inside of their systems. With that, this is just a little bit more about broadly define this notion of, and this is the EDRM for those of you who are not as familiar. This is a great model that just kind of gives you a sense of that process, that business process. But again, this just kind of reviews those important points that all of those different divisions have to be in coordination, and that these are the things you need to do: notification, identification, ensure those tasks are suspended when necessary, and then ensure that you actually have copies of the data. Barry, did you want to talk, get a little bit into the nitty-gritty of what the legal hold process is actually like from legal's perspective?
Certainly, Alon. Thank you. And hello, everyone. A couple points I'd like to make at the outset are, one is, and it's a mantra that I think Alon's already touched on, and that is that throughout our presentation we're going to be discussing the need to have a clear and repeatable process in place so that your end result is fully defensible when and if it comes into question. And that's a really critical aspect of things. And another point that we will be discussing probably repeatedly is the need to have a well-thought-out legal events team. And Peter will mention that in some detail. But for now, you should be thinking about those people and the roles of those people that in your organization that should be involved at the outset of a legal issue. And one of the key points, we say at the outset of a legal issue, is to know when a legal issue is presenting itself to you. And in that light, we call it a triggering event. And triggering events can be the notification that a former or current employee is filing a discrimination action against your organization, or there's a product liability case, or intellectual property issue, or the threat of a governmental investigation. And those are all triggering events that give rise to the duty that Alon mentioned to preserve data. As a result, there are certain steps that need to be put into place in order to make certain that you're in compliance. And one of the first steps is, as Alon mentioned, is to identify those individuals and then notify them, which means to have a clearly and well thought out litigation hold and preservation strategy in place. And that's probably, from the outset, the most important thing to have underway. And then once you've got that in place, there are certain do's and don'ts, certain things that are important for an organization to inform its custodians and its records management people of what they should and shouldn't do. And one point regarding custodians is it's not just employees of an organization. It could very clearly be third parties, consultants, and vendors even, who have a legal obligation to you as their contract benefactor to maintain records, and they may need to be considered as recipients of your legal hold notification system. So it's important to identify your custodians to be fully knowledgeable of the contents of the litigation hold. And that means the custodians are encouraged and need to read and acknowledge their hold notice, which should be clearly and concisely written, and also offer to the custodian a person within the organization to contact if there are any questions or requirements for clarification. And as part of the hold notice, as Alon stated, and we'll keep on repeating, it's important that the IT team also be notified with their expected obligations to suspend any auto-deletion policies, to remove any restrictions on mailbox size, and so forth. And you, as a person managing the litigation hold, also need to know where all that data is located. So it's important to keep track of thumb drives, external media, CDs, DVDs, external hard drives, personal computers, smartphones, tablets, as well as hard copy documents. And one way to identify all that is to use a custodial questionnaire to inquire about that, among other things. And that will assist you in managing your obligation of the litigation hold. And as far as employees are concerned, in the U.S., there's not a big expectation of privacy in the workplace. And with respect to smartphones and tablets and personal computers and so forth, under a BYOD policy, bring your own device policy, again, if there is business record information stored on those devices, again, there's no expectation of privacy if personal data is commingled with business records. And by the way, the BYOD moniker currently, as Alon mentioned, the vernacular in the industry changes from time to time, is now being characterized as an MDM policy, or mobile device management policy. And custodians also need to be advised not to delete, copy, or move any of the records that are subject to the litigation hold, because it could affect the internal metadata of those particular electronic documents. And if we go back one slide, please. There we go. To this one. Thank you. And as I mentioned earlier, there's external media such as flash drives and external drives, but it's also important to preserve web-based resources such as those pictured here, webmail, cloud-based storage systems, and the like. And we've all read where employees or former employees have moved on to new jobs, and they've been able to, before they left, copy corporate data to a webmail account of their own, or transferred files up to a web storage system such as Dropbox, or have posted things inappropriately on Facebook or Twitter. And those are areas that are ripe for investigation and should, in fact, be addressed in the custodial questionnaire to be identified, and most likely need to be collected in some fashion.
Barry, I was going to ask you to maybe touch a little bit on, maybe you can give a little war story around that notion of kind of social media use and its danger, in the employment realm. We're seeing much more of that. And that maybe you can give a little bit more color around that specifically, and maybe some things to consider if you're, coming from the corporate side of things.
Well, absolutely. There was a recent man-made incident that caused environmental damage, and the parties involved were clearly interested to know what the employees and the persons on site when the event occurred were saying on social media, on Facebook, on Twitter, with their private accounts. And we were able to identify those individuals through the use of a custodial questionnaire that in turn identified which custodians talked about these in social media. And that was informative to counsel who was preparing the client for the likely litigation. And we see that also in job-related matters where a disgruntled employee is talking in some fashion on social media or in Twitter or on various blogs, and those are also areas that are of keen interest to attorneys representing the employer in situations such as that. And then there's a very recent case that we actually are writing about today in a blog post, the Brown versus TellerMate case, which involves Salesforce.com, which is a cloud-based resource. And in that particular case, which is getting a lot of coverage in the press right now, the e-discovery press, specifically because it's a cloud resource, but in our opinion at BIA, the real crux of the issue is that Salesforce.com is just another data repository that counsel and management forgot they had the obligation to preserve when the matter arose, and that resulted in sanctions against TellerMate for not preserving that data at the appropriate time. And so as a result...
Barry, I will mention that I think a little bit later on we talk about some exercises, some processes you can use, including one that we call the implicated systems exercise, which is what you do early on to walk through with counsel to determine whether there are systems outside of the kind of standard email and workstations that may be implicated by a particular issue or matter. So we'll get into that in a little bit. Go ahead. I didn't want to interrupt you. I think you're about to kind of get into the impact of non-compliant collections and those kinds of things.
Exactly. And this slide here is very clear. Non-compliance has significant financial costs, and we identify these here. But one of the most significant of the costs is the time involved, because failure to do what is appropriate to collect and preserve, identify, collect, and preserve data results in this list of items. Increased soft costs, meaning human costs. Hard costs means you're spending extra money to do what it is that you should have done in the first place. Employees are disrupted because they need to be recontacted and recollected, and it causes additional costs within the IT department and so forth. And with sanctions, as I mentioned in the TellerMate case, and there's many, many cases where failure to do appropriate preservation, collection of data, documents, and the like results in adverse inferences by judges to the offending party that costs dear money. And then, of course, increased e-discovery costs, all of this multiplies and multiplies, and means that there could be more review costs. And those of us who are intimately involved in the e-discovery space know that document review is probably the single most expensive portion of the e-discovery world. And talk about just a couple of cases. I did mention the TellerMate case in some detail, which is a very hot one. There's another one that has been spoken about in the blogs just recently, and it's not on the slide, Hawley versus Emphasis Corporation, where there was an EEOC complaint filed, and the supervisor's laptop, which held critical information, was not properly preserved. And just in the last 5 or 6 weeks, the court imposed sanctions against the offending party that will be determined when the case is finally resolved. And in another case, the A&M Florida property case, the plaintiff's counsel failed to produce 9,500 email records. And the court made it really clear to the attorneys, as in the TellerMate case, that they have an obligation to understand their clients' information systems in order to conduct an efficient and accurate e-discovery process. And the case law is replete with instances like this. And then just a couple of other considerations. One is, I mentioned, not a whole lot of expectation of privacy in the U.S., in the EU, and in other jurisdictions outside of the United States. There are different privacy rules. So if you're going to need to collect from custodial sources outside of the U.S., you should be aware of what those privacy rules are so you don't yourself be hit with fines and charges and so forth. So it behooves you to check with local counsel. And I want to leave with one last point. The guiding principle from the Judge's Guide to Cost-Effective E-Discovery from the EDI is the single most cost-effective reduction method is the focused collection of records most likely to contain relevant information. And with that, Peter, up to you.
All right, thank you, Barry. So what I'd like to talk about now is how records management and information governance applies in this whole legal holds arena. One of the key things that I think is that people who are involved with records and information management they are able to look at the entire organization. They look across the silos versus what somebody in IT is focused on, just the electronic information. Legal is looking at it from a legal view. Records management looks at it from a overview of the whole organization. They cross the silos, and that's really what information governance does, is it connects all the silos that are out there. So what are the responsibilities? Well, Alon and both Barry had mentioned creation of a legal event team. And as I was listening to him, it suddenly dawned on me, a legal event team is similar to a disaster recovery team. You have a set number of individuals on there. You would typically have a C-level executive, whether it's somebody from the general counsel, it could be a CIO, CTO. There needs to be some C-level executive in charge to take responsibility and to take a long overview. The rest of the legal team, the event team, would be somebody from records management, somebody from IT, somebody from legal. That's your base team. Once an event starts, then you would pull in other people from the affected areas to make sure that you have everything there. And now that you have
Peter,
a legal, yes, sir.
I'm sorry to talk over you. I just want you touched on that executive sponsorship. I'd like you to, when you're finished with your thought, give a little bit more detail around why that's important.
Okay, not a problem. So once you have, and Alon or Barry, one of the two, Alon, I believe it was, basically touched on exercises. So if I look at it as a legal event team being similar to a disaster recovery team, you may want to do some tabletop exercises to exercise what that legal event team is doing in the case of litigation. You may have a plan in place, but you don't know when litigation is going to occur, and then you have to put that plan into place. If you run exercises, you get to test that plan. You get to see how it's working and where there might be holes in the plan. So that makes sure that your plan and your event team is up to date on everything. From a C-level executive thing, that C-level person takes ownership. They have the overview of the whole organization, just as records management does, but they have the power and the authority to make sure things are happening the way they're supposed to. They are the ones most affected by it. If we remember Sarbanes-Oxley, C-level people can go to jail or be fined for not complying with the laws. I'm not sure what else you would like, Alon, on that regard. I just see that they're the leader. They're the one in charge of the whole event team and making sure
I think
it's
that's
going
the
forward.
important point. Yep.
So then we have to make sure that nothing is overlooked. That's where that exercise comes in. You can run scenarios. I used to work for a oil and gas company years ago that had an oil spill recovery team, and they regularly ran exercises to make sure everything was done. So if you run these exercises, you can sit here and identify, where is the ESI? Am I dealing with a HR complaint? Where does HR have their stuff? Is it also in the finance area with regards to payroll? Is there information in the department where the employee was located? Identifying hard copy materials. 20, 30 years ago, legal holds, legal events all involved hard copy, and that was under the control of records management. But as we got into the electronic arena, starting in the late 80s, early 90s, we started creating documents out there in what I would say the wild, where there was no control. Records management didn't have it in their foresight. And then the litigators started realizing that there's information out there that we can take. And they started with email and saying, hey, give us your email tapes. And then they discovered the document management system and said, we want that information. So identifying where the ESI is, identifying where your hard copy is. We still have hard copy. It's not going away. But as you go forth, you've got your retention schedule, but you need to sit down with the organization that's been targeted with the litigation or the audit or the investigation and start asking, do you have any of this material in a hard copy format? Because one of the key things with hard copy materials is you've got marginalia. People put notes on things, and as records managers, we know that if you put writing on a piece of paper, you've created a new record of something, and it must be preserved according to the hold or to the retention schedule. Databases are something else. There's more data out there. We've got dark data is the term being used. Data that's been out there but it's not being used, but it may be subject to the litigation hold, the litigation event. Next slide, please. So what we see here are some want ads. Robin is doing a bang-up job. She tracks what jobs are being advertised for legal holds. that's a responsibility for somebody in records management or in the technology area. These are just 3 examples that she's found recently of where an institution is looking for a records manager, and legal and discovery is part of those job duties. Records management, IG, is ensuring the compliance that we have going forward. So you can run searches all yourself to see these things. I'm seeing the same things. So records management and IG is getting a higher profile across industries as they see the need for it, as they understand that they have to have this broad exposure. Next slide, please. So first response. We mentioned earlier a legal event team. We get notification that there's an audit, investigation, or litigation coming down. The legal event team starts off who does what. One of the key things is identifying the custodians and the groups that are potentially involved. They receive a notification. We've drafted and finalized the notification, and then it gets sent out, and those people who receive it, those groups that receive it, have to acknowledge it, that they've received it. That creates a chain. But it's not just a one-time notification. Part of that legal event process, that protocol, is how often do you notify people that they are still subject to the hold or that they've been released from the hold. Just a one-time notification does not do it. You have to continually notify them and update them as to the status of the event. And I've seen stories where the courts have sanctioned somebody for not doing that continual notification. How often you do it is up to how you've established your protocol. And these people need to be aware of what's going on. Identifying the data sources and systems. This is where you go into those people, those custodians, those records owners, those business owners, and say, this is what we're looking for. What do you have? Where is it located? You may even be doing some sort of analysis of the systems to see how they're interconnected. Are there retention-related issues? One of the first cases that I can remember, and I think a lot of records managers hung their hat on years ago, occurred in the 1980s or late 70s, and it was called Carlucci versus Piper Aviation. Piper Aviation lost the case because they had destroyed records that were related to the litigation, but they had not been retained in accordance with the records retention schedule. 2 different trigger events were involved, and the key trigger event was that the retention didn't start until the engineering department signed off on the plans. Engineering had not done that, but they had gone ahead and destroyed the records, and they had put no hold on the records. And as a result, they lost the case and were sanctioned for $10 million. So think about that. In the 1980s, $10 million was quite a significant sum of money on that. So you need to really look at that retention schedule that you have, what comes into play, what records that are involved with the litigation or the audit or the investigation are under that retention schedule. Next slide, please. So some anecdotes, war stories. I just mentioned Carlucci versus Piper Aviation. Coleman versus Morgan Stanley in the 1980s was very significant in that Coleman had sued Morgan Stanley saying that they had done something wrong. There was a need to look for emails. And the email team at Morgan Stanley kept coming back and saying, we have produced everything, we've produced everything. Well, they finally went back to the well once too often and told the judge, Judge, we're sorry, but we've just found 1,400 more email tapes in a closet. And the judge wasn't really happy with that. And I don't remember the dollar value, but it was a significant amount. It was an adverse inference towards Morgan Stanley. They lost the case, and they lost the money. Arthur Andersen, Enron in the 2000s. Arthur Andersen, classic example, they anticipated litigation. The Assistant General Counsel sent out an email, poorly worded email, that told everybody, please make sure you're in compliance with our records retention schedule. Now, keep in mind that Arthur Andersen, one of their services as a consulting company was to help organizations with litigation and legal holds. And they sold this as a service. It was a big binder worth of stuff. But this thing of, please make sure you're in compliance with the records retention schedule was read by the office in Houston of, oh, we better destroy stuff to make sure we're in compliance with the retention schedule. As a result, they destroyed records that were related to the Enron process. End result was Department of Justice brought suit against Arthur Andersen. Arthur Andersen lost. Arthur Andersen is no more. Now, eventually the case went to the Supreme Court, and Arthur Andersen, the verdict was overturned, but that did no good because Arthur Andersen no longer existed. Now, I worked for a company back in the early aughts that was going through a merger, and the Department of Justice announced through a newspaper that they were going to look at it from an antitrust standpoint. We had not received, I was working in the general counsel's office. I got a call from the IT department saying, is there going to be a legal hold issued concerning the records? We need to know now what is going on. I went to the appropriate counsel, the associate counsel, who issued the legal holds and asked, are you going to issue a hold notice with regards to this potential antitrust investigation? And the individual went, oh, yeah, I think we should issue one. That's where the legal event team comes into play. If there's any sort of notice of litigation or something coming down the road, that is your triggering event. The legal event team would then take hold. We didn't have a legal event team that takes hold. Back on one of the other ones, when we're identifying ESI, one of the things is, and it comes down, if you have a document management system and an electronic records management system, the things in the ARMS have been declared records. But what happens to those items that are in the document management system not declared as a record? There has to be a way to identify what's over there that is subject to the hold and to segregate it and protect it and preserve it from any sort of destruction, because it's not under the control of the ARMS, which can apply legal holds. Company I used to work for, we were developing technologies and techniques that would allow customers to protect and preserve those items over in the document management system. I'm sure
Peter,
I've got other. Yes, sir.
You're making a distinction there between kind of records and documents, I think. And just for the edification of those folks that are not as steeped in the records management world, do you want to just kind of give a quick sense of the differentiation of those two, what kind of just
Sure.
a document versus a record and how it relates to the legal hold side?
So really the differentiation of documents versus records really only came about with electronic records management systems, because in the paper world there was no concept called I need to declare a record. In the 90s, we started getting document management systems where people could collaborate. You could put a document up, you could draft it, you could review it, you could change it around, you could finalize it, you could publish it. Technically, that was a record, but it could be modified. There was no way to lock it down. Once you produced something on paper, it was locked down. Electronically, you couldn't do that until electronic records management systems came into play, after document management systems were in existence. So you had to develop something called declare it a record. And that took a finalized item in the document management system, declared it as a record, placed it into the ERMS where it was locked down and became immutable. It could not be changed. So that's the difference between a document and a records management record in an electronic sense. The things that are documents can be changed all the time, so you have to figure out a way to lock them down. Items that are declared as a record are locked down, immutable. They can't be modified and do it that way.
And I think one of the practical kind of points to consider with all of that, what Peter just kind of described as that differentiation, is that when you're gathering or preserving, there may be a different mechanism by which you go around about preserving, say, documents in a document management system or DMS, as opposed to records that have already been placed in a records management system, a lot of times that records management system is a well-structured system, and so there are usually easier mechanisms to essentially preserve or ensure that those records are not being deleted, as opposed to say a document that just may be in a document management system, which is still a structured system, but it doesn't have the same. Let me use the word discipline around. Yeah. Okay.
It's not as robust. It can't lock it down. You have to use some different techniques or different applications to grab that material. And in the ERMS, you have the ability to put items on hold, and that prevents the retention, the disposition process from destroying those things, or even being presented as, should I destroy this? It's locked down and on hold. Yep. But yeah. Definitely on that.
And that's that important coordination with the information governance folks. Is it does take someone on that RIM side to go in and ensure that the records that are now being placed on legal hold also have those taggings. So that again is that kind of communication aspect.
And definitely that also is part of that collaboration of what are you searching for that needs to be put on hold. I can either put it on hold from a retention schedule standpoint and lock everything down from that, or are you searching for specific records related to this incident so that other items can continue on and follow their retention schedule. So there has to be that sit down that just says, what is it you're searching for? And then the records management IG people can search through the system and identify those items.
Great. What I thought to do is, since we're kind of on this pathway of war stories and anecdotes, Barry, maybe you could give us a story or two that may resonate with our audience today, just from the legal perspective around holds or preservation.
Certainly. I had mentioned earlier when discussing the definition of custodian, the notion that third parties many times have obligations to have their records, or that the company has, or the client has obligations to impose upon third parties to preserve data. And we've seen this in any number of cases where in the pharma industry or in any of the IP industries where there are consultants in play advising your client or your company of matters that are pertinent to the issues at hand, that those third parties, these consultants, are contractually typically obligated to work with you and support you in defense of any claims or in prosecution of any claims. Hence, that means that their records are subject to preservation, collection, review, and production to the opposing side in many, many instances. And we see that today where companies are lean and they rely more on independent contractors, these consultants, to provide insights into their business, necessary insights into their business, that their records that they hold personally are important business records of yours that need to be collected and preserved. And conversely, we've also seen bad instances of mobile device management practices where independent contractors, salespeople perhaps, who are independently employed by a company using their own devices, and with a conscious effort to have those independent contractors only use personal devices, where now the information contained on those devices in text messages, emails, and call records and so forth are important for managing litigation for you or your client. They're not accessible because the BYOD or MDM policy does not address using those individuals' devices. And that we've seen that create a real conundrum with the client organization, because they cannot get access to these records, and the records are vitally important to them. So having, as I said earlier, a properly thought out policy regarding smartphones and tablets and personal computers and so forth is of critical importance as you're trying to protect your company or your organization or your client's performance in the legal world, that you have that policy clearly in place so that you have access to the information when you need to have it.
And Barry, can you talk, are there some practical tips, for example, something you can do with respect to your agreement with the contractors or vendors? Is there any language you can put in those agreements, or is there some coordination early? Just talk a little bit about a couple steps you can take to ensure that it doesn't become problematic later on when you have to go for those items.
Well, certainly. There's a couple of points to address. One is the issue of privacy. And as I said earlier, the notion that in the U.S. workplace in particular, there's not a whole lot of expectation of privacy when you're commingling business records with personal records on the same device. And in order to combat or work around that notion of privacy, it's important to have in your device policy a very clear statement that recognizes to the person who's providing their personal device in the business setting to clearly recognize that it is likely that your data may need to be collected if and when there's an event, the proverbial triggering event that we've been talking about here, to permit that to happen and also provide appropriate safeguards for the personal information so that it doesn't get beyond the e-discovery phase and out into production.
So if I may,
Great.
Barry's mentioned third parties and they're subject to legal events, and that triggered another war story involving BP and their Gulf of Mexico oil disaster. There was a third party working with them that provided services. An individual in that party, in that organization, destroyed records that were definitely relevant to what had happened in the blowout. However, nobody had told that individual, do not destroy these records, and as a result, that particular third party was heavily sanctioned by the court system for destroying those records that they were deemed to. And I've got the story somewhere, but I didn't want to mention the name without, being incorrect on it. But there's a clear instance of a third party, being involved and not being told don't destroy something. When I was with another company, we would write contracts such that we had a clause in there that said records related to our company were to be retained in accordance with our records retention schedule and not the third party's records retention schedule. And many of our third parties would agree to that. So that's another way to affect a change, affect something with the third party.
That's a good point. Thank you, Peter. So what I want to do now, since we only have about 9 minutes left here, is I just want to quickly go over kind of the IT side of things, because we do want to try to get all those perspectives. I think that the primary points from the IT perspective is that the IT folks are the people on the ground. They're the people in the mud that's actually doing the gathering. So to a large extent what we talked about today are the notification side. That's legal, sending out those notifications and managing the process at a high level. The RIM side, or the IG side, which is ensuring that those records are tagged correctly and that they're not being set up for disposition, and that they're coordinating well with the legal side. But then you have IT, and those are the folks that actually have to go gather the stuff. And the most important part of that is you want to ensure that you're gathering the documents, you're gathering the data, you're moving those bits around in a manner that's not altering critical information like metadata, like date information, and path information, i.e., like, for example, the original location of things, which could be very important to the attorneys and to maybe the regulators if you're talking about an investigation. And so you want to ensure that the IT folks that are involved are either using the right tools and software, and there's today a lot of good tools out there that are reasonably priced and easy to install. But ultimately you want to make sure that IT is using the defensible protocols. You don't want an IT person on the stand having to defend his or her process unless that process is tight. And ultimately, if the process is a good process and it's being followed and executed right, then a lot of times you don't even have to go as far as putting anyone on the stand, so to speak. But ultimately, the IT folks need to know what is it that is being gathered, what needs to be suspended, what are the people involved, what are the methods used to gather those documents, and also have validation processes to ensure that their actions of gathering the documents aren't in and of itself altering or deleting information. Another important thing to understand is to select the right approach to go about gathering or collecting documents. We are at a maturity level in the industry that it's no longer a good idea to try to home grow your process, to use robocopy and some scripts and some databases and point everything to something and try to make it work. These days there's a really low cost and reasonably cost software that's not too hard to install and to manage that really helps you along the whole process. You have to ensure that there's a chain of custody is maintained. You have to ensure that you're using a defensible process where you're not altering metadata and raw content and that kind of thing. You want to make sure you have error handling, you have audit trails. These are all things that are tough to build yourself, especially these days. You don't really need to because there's software and tools out there that really make it easy and are inexpensive. So ultimately, you want to do these things. You want to use the right tools and software because you want to ensure that you're being efficient. Most of the cost, besides the review cost at the attorney level, most of the other cost of discovery and really preservation activities are borne by the IT organization. And so we're starting to see a lot more of the shifts of budgets from IT to legal because ultimately IT is saying, we're just facilitating the process, but the business process is actually owned by legal or by RIM. And so before you get into too much of a combative mode with IT about budgets, it's a good idea to think about this as an overall process and see maybe where you can carve out those costs. But to the extent IT is focused on using tools and kind of creating efficiencies, then those costs will get lowered regardless. And then one of the most important parts of this is that you do want to shroud or you want to buffer your IT folks who know where a lot of bodies are buried from having to be put on the stand or having to be deposed and then potentially opened up to other lines of questions. And I'll just kind of end before we open up for a few questions. We have a few more minutes. Is just the maturity model. This is a paper that we published and that has gotten a lot of support from kind of the knowledge leaders in the industry. What this does, it really just takes a standard IT maturity model and places it over the preservation, the legal hold and preservation process. And it's a very good and easy and quick way for you to understand where you are, where your organization fits on the level of maturity with respect to preservation. Obviously, number one is ad hoc and chaotic. You're all over the place every time you do it a little bit differently. And then the most mature level, 5, integrated and optimizing, where you have connectivity between different systems. You have software that's automating the processes. You have people and roles and training and all of those other things that you usually see when you have a mature, optimized process inside of an organization. And then in between 2, 3, and 4 are just levels to get you to the kind of top level. And frankly, we find that most organizations should really be at the very minimum in at least at level 2 or level 3. Now we're going to send a link around to this maturity model, and you can download the white paper for free. I do urge you to read it. It's not that long, and it really helps you get a better understanding of where you are, where your organization is, and then where you need to go, where you have to be. So with that, I know we have just a few minutes left, and hopefully we've been able to answer some of the questions I've seen come through. Some of what we've talked about has hopefully answered those. But to the extent there are others, Robin, I'll turn it over to you. I think we have a few minutes if we want to field just a couple questions at the end here.
Yeah, we've got a really good one. Are you aware of any organizations today who employs information rights management software to track convenience copies on mobile devices and copies distributed beyond the organization's firewall?
That's a mouthful. I'll take a quick stab, which is obviously whoever's asking that is in a more progressive state than many other companies that we talk to. We don't see a lot of that. We see companies, especially larger companies, the Global 2000, starting to go in that direction. To a large extent, I think that's just because that's just another enterprise software that has to get installed and managed, although that's probably a very good one because it solves not only the discovery and the litigation and preservation problems, but potentially solves some ECM, enterprise content management, and information security. Coming from, I'm a CISSP, so coming from the information security side, to me that type of system is very helpful. And then of course on the IG side, I think that is really, you get a lot of bang for your buck because of kind of managing those copies outside of the actual original record set and all of that. So I know, Peter, if you have any remarks with respect to that. I know we might have lost Peter there.
All right. Do you want to? I've got one more question, Alon, and you may have touched on it, but it said a third party such as a supplier must comply with our company's legal hold. On what basis?
Yeah, I think Barry gave a pretty good answer for that. I think the idea there is to the extent that the third-party supplier, the vendor, has data that may be implicated by the case at hand, then you definitely don't want to ignore that data set. You want to ensure that it's being preserved, or at least you know that if it's just duplicative of what you're already gathering, that you've got that managed. So at the very minimum extent, that inventorying what the vendor has, and then a little bit further down, it would be actually ensuring that that is gathered or preserved in a way that can be used later on. So I think that's really just on a case-to-case basis. But what Barry was saying was that more and more companies are relying on third parties for outsourced IT and outsourced applications, such as, we mentioned Salesforce.com. And so to the extent that you're going to rely, your business operations are going to rely on critical outsourced systems or outsourced providers, then you definitely want to have some protections in place when a litigation comes around.
And let me just add on that, Alon, and that would be contractually. When you're entering into agreements with third parties, provide an appropriate clause that counsel can provide to you that incorporates just that notion that the third party is obligated to cooperate and make business records available on when required by court action or other legal reasons.
Fantastic. That brings us up to the top of the hour, and we'd like to thank everyone who participated in our webinar today for their valuable time and encourage you to go to our website on the education page and check out what's in store for the remaining months of 2014. We'll be back with you again on October 16th when Brian and Barry will present an encore presentation of Risk and Responsibilities, the Ethics of Legal Hold, with updated information for 2014. I want to thank our panel today for participating. Thank you, Alon. Thank you, Barry and Peter. And encourage all of you to answer the brief survey as you exit today. Thank you, gentlemen.
Thank you, Robin.